Ms. Mackel-Wiederanders, welcome, and have a seat, and when you get comfortable, you may begin your opening statement. I should say when you get settled. I don't know if you ever get comfortable.
Right. Interesting choice of word, right? All right. Good afternoon, everyone. My name is Shelley Mackel. I am very grateful to be here, and I want to thank you for your service. I know it's been a very long day for you all, and I appreciate the opportunity. I'm going to start with a little bit of background. I was born in Cedar Rapids. I grew up in Marion, Iowa, right outside of Cedar Rapids, and after graduating high school there, I went on to get my bachelor's degree at UNI in criminology. It was there that I met my husband, Kurt, and we married in 1996, and my husband and I had our child, Sullivan, in 1998. Sully is now a junior at the University of Iowa. He lives about a block from where he went to daycare when I was in law school. And so when I was in law school, I decided that I wanted to work in public service, and so I started with an internship at Iowa Legal Aid. And from that experience, I decided that that's where I wanted to start my career, and in fact, that's where I spent the first 12 years of my practice. For those who don't know what Iowa Legal Aid is, or maybe you're not very familiar with what it is a law firm. It is one of the largest law firms in the state. It is funded by some state and federal funds, also by private grants and donations, and it exists to provide civil legal services to low-income Iowans. And the reason for that is that if one can't afford an attorney, the legal system can be daunting at best, and so legal aid provides attorneys to people who can't afford them. And so I started my career with legal aid as a staff attorney, which means that I maintained a caseload of 70, 80, 90 cases at any given time. The casework often has urgent deadlines, and there is always very, very quick turnaround times on those cases. And we were able to do some impact and systemic work, and I was able to participate in that. That usually happened through the appellate process. But the day-to-day cases really were district court cases that dealt with people getting access to basic necessities like income maintenance, housing stability, and safety. And some people think that legal aid cases are insignificant or small or simple because they don't deal with high dollar amounts. And that's not been my perspective. My perspective, and certainly the perspective of the litigants that I've worked with, is that there aren't any small cases. And so I wanted to give a couple of examples today that I think help to illustrate my perspective and what I might bring to the Court of Appeals. The first case I want to talk about is one where I was assisting a couple who they were being evicted from their apartment that they had lived in for several years. And the reason they were being evicted was because they were $40 short on their rent that month. And the reason they were $40 short on their rent was because the wife had been in the hospital for 10 days and she had been unable to work, so her paycheck was short. They were unable to scrape together the full amount of rent. And when they offered that payment to the landlord rejected it, which he had a right to do. And so they were facing an eviction. And they came to me because they wanted help with the case, and I wanted to help with the case not because I thought they had a great legal argument, because they didn't, but because I was concerned about how wrong it felt that they were going to be evicted after making 3 years worth of payments and being $40 short. And so I thought I could at least help to explain that to the judge. And so we prepared, we went to hearing, we provided our evidence, and the landlord provided his evidence. And on that day, the magistrate asked me the question, Ms. Mackel, are evictions brought at law or in equity? And I was given that softball so that I could answer, well, Your Honor, they're brought in equity. And he said, so I can take fairness into account. And I said, yes, you can. And he dismissed that action. They were able to pay their full rent the next week, and everything was fine. And so that's a case that was only about $40. It was a small claims case, but it was not a small case for those litigants. The second case I want to talk about is a case that started when a client came to me and she told me a story that seemed unreal about how her husband had been stalking her, to the extent that he had actually cut her brake lines and endangered her and her children while they were driving to school. And he was so good at it, he was so skilled at stalking, and he was so good at covering it up that no one believed her that this was happening. And so after meeting with her, I believed her. I decided to take her case, and that started a nearly 3-year-long divorce and custody case that ended in a 4-day trial that only had 2 witnesses. So you can imagine that that is unusual for a case of that size, if you will. And I want to be clear that in family law cases, which I did a fair share of, I don't think that anyone ever wins a family law case. At the end of it, a marriage is broken, parents are split, children are dealing with that process, but there can be positive things that come out of a family law case. And in this case, there were. We worked very hard, my client and I, to prove this case and prove how insidious the abuse and stalking was. And the judge was persuaded, and she ended up ordering that my client certainly got her divorce, of course, but she also was given a lifetime protective order. She was given sole legal custody of her children, and she was given supervised visitation only for her husband. And so that was one of those cases, again, where we weren't talking about $1 million in assets, and we certainly weren't talking about 6-figure alimony payments or anything of that sort. In fact, she and I knew that she would never see any support. But she called me the next day and told me that she slept through the night for the first time since she had split from him. And so, again, not a huge case, but that was no small case for her in terms of what it meant for her well-being. And so now that I've been at the city, I've dealt with those $1 million cases. I have worked on constitutional matters. I've argued in this courtroom constitutional matters. I'll be arguing in the 8th Circuit in the next couple of months. But that work doesn't in any way overshadow the importance of the work that is done with low-income clients and with smaller cases. And so what I would bring in terms of a special, I think, skill to this court is, in addition to what I've outlined in my application, is a commitment to treat cases of all sizes with respect and with an acknowledgement to the fact that none of them are small to the litigants involved. And so with that, I'll finish my opening statement, and I would welcome any questions.
Thank you very much. We'll start with Ms. Pearson.
Thank you very much for your application and for being with us today. I always like to see somebody from Lynn County besides myself and Connie over here, so that's great. You know, you have a really unique and impressive background and have been involved with some very, I'm sure, heart-wrenching situations at times. And now, should you be appointed to the Court of Appeals, you'd be working in a little bit different setting, the panel setting and so forth. How do you see that transition going, and how, in your mind, just making that transition?
Well, the panel doesn't appear to me to be a transition that would be a difficult one. I think collaboration is something that I've always worked with in my experience. Certainly at the city, there's a heavy collaborative nature there. And I think opinions are better and legal analysis is better when you have more than one view looking at an issue. In terms of making the transition, though, from being an advocate to a judge, I think one of the experiences that many people don't necessarily know about legal aid, which I did for 12 years, is that it is essentially a constant merit screening, meaning you are gathering facts, applying it to the law, and deciding if if you can actually see a good opinion come out of a court. And the reason for that is because we don't have the luxury there to take every case. And so if you have limited resources, you're going to take the case that once you look at the facts, apply it to the law, you have a really good idea of what a judge is going to say at the end of the day. And so in a lot of ways, it is not different than judging. And it just meant the difference between whether we would accept a case or have to decline a case. So I think the transition will be fairly easy to me because there is that sort of normative experience that I've had.
Thank you.
Ms. Bowden?
Yes, thank you. Good afternoon. Could you please tell me what the difference is, or your transition from Iowa legal aid to being a City of Des Moines city attorney?
What the transition was like?
Or what the difference in your practice?
Oh, sure. Well, in both positions, I'm a general civil practitioner, but there are some differences. Of course, there's a difference in terms of having an individual client versus having the city as my client. But the legal aid practice was largely focused on kind of short-term district court cases with really pretty quick turnover time. And really having to spend a lot of time turning clients away also. And so there was a lot more education that was happening with my position there because you were trying to teach people to self-advocate. At the city, if there's a case, we take it, and there are a different kind of civil practice that I'm doing now. So for example, I'm doing more personal injury work, which is something we just didn't do at Iowa Legal Aid because those cases were fee generating and private attorneys could take those. At the city, I'm also engaged in a lot more federal practice, a significant amount of motion practice that just wasn't part of my work at Iowa Legal Aid. So it's bigger, there are bigger dollar amounts attached to the work now, and as a senior litigator, my caseload is specifically meant to be a more complex litigation.
Thank you.
Mr. Berger?
No question.
Mr. Diaz?
I noticed in your application that, I think you indicated 38 Court of Appeals and, you want 2 or 3, I can't remember the number of Supreme Court appeals. Can you talk a little bit about how much of that was at legal aid, how much of it is at city, and what kinds of cases are we talking about?
Mm-hmm. Well, the kinds is going to be a harder question, but I'll try to give a sense. The bulk of my appellate cases would have been at Iowa Legal Aid, but I've had, I believe, 6 or 8, I think probably 8 now with the city. And so they have been of the sort that were family law related, as was most of the as a big chunk of the Court of Appeals cases that are heard. At Legal Aid, I also assisted with a couple of landlord-tenant kinds of cases and a lot of more sort of civil procedure-related cases that were based even, the context of the case may have been a certain substantive area of law, but it was really about some area of civil procedure. One of them that went before the Supreme Court was, the counting of days and what happens with EDMS, and so it was one of those early cases when we were trying to sort of figure those things out. My Supreme Court cases, that was one of those Supreme Court cases that I was just talking about with the timing and EDMS. But we also had another case that I worked on that was Doe versus Iowa Department of Human Services. So that was, a 17A case that went up on appeal, and we ended up winning on an ultra vires argument. And at the city now, I've had 3 cases that have been before the Supreme Court, and they have nearly all been about the really popular topic of automated traffic enforcement. Does that answer your question?
It does, thank you.
Ms. Law?
No questions.
Mr. Bevel?
No questions.
Ms. Sinclair?
Have you ever applied to the district court? And if not, why?
I have not. And the why not is not that I would never apply to the district court. It is that I have now just decided to begin thinking about serving in the judicial capacity, and so this was looked like the best fit for me to focus on at this point because of my appellate experience. But that is not to say that I would not. The simple answer is I didn't believe that I was in a good position to move into a judicial capacity right now, or before this, and now I do.
Ms. Stiekma?
How important do you think that judicial temperament is to our applicants?
I think it's very important. I think it's most important at the district court level because there is so much contact between the bench and litigants and lawyers. But it is equally important, of course, during oral argument to have that temperament. But I have seen sharp opinions at times, and so I think it's important also to have a respectful temperament in writing as well. So I think it's very important, and it can weave throughout not only oral argument, but in the tone of opinions.
Thank you.
Mr. Goodman?
No questions, Your Honor.
Mr. Bloom?
Jimmy, you were president, are you currently president of the Iowa Organization of Women Attorneys?
I was president of the Iowa Organization of Women Attorneys for 2 years. I finished my term last year, and so I am the immediate past president.
So you had a long pull in the board and officer positions there. What does that say about how you're perceived with your fellow women attorneys and collegiality and things like that?
That is a workhorse position, so I think that I'm perceived pretty well among women attorneys. There is a really collegial atmosphere among women attorneys in Iowa, and so not only with the statewide female bar, but I also served in Polk County with the Polk County women attorneys, and had a couple of very active roles there. And so I've met and been able to learn from and be mentored by a number of women in the Iowa bar, and I'm very appreciative of that.
Okay, thank you.
Ms. Conover?
I don't think you ever really give up any of your IOWA duties just because
You are absolutely right.
go off the officer list. I wanted to ask you to touch on for us, I'm familiar with my colleagues in the Cedar Rapids Legal Aid Office, the fact that legal aid couldn't just take any case they wanted to up on appeal because of resource issues. And so you had a very specialized process to screen those cases and then prepare the briefing and the arguments. Could you talk to us a little bit about that and your role in that?
The preparation process?
Yes.
Sure. And one of the things that we always wanted to make sure also when we decided to take a case on appeal was that we weren't going to create bad law. And so, that was definitely a part of the screening process, was to just make sure we were not going to do any harm. But we had what's called an IPAP process, which is an intensive preparation for appeals. And I was basically assisted one of our litigation directors with that process. And so that meant we oversaw the writing of briefs, made them better through that process, and then no one went to oral argument without spending a rigorous day of being in front of a dais of several attorneys from Iowa Legal Aid, going through their oral argument, being challenged on the weak points of their argument, and helping them to drill down to the most important parts.
Ms. Roberts? Ms. O'Brien? Mr. Horvath? Mr. Gray?
No additional questions, thank you.
I don't have any questions, so we really appreciate you coming this afternoon. We wish you the best of luck.
All right, thank you.
Thank you.
Very much.